because I was the one who registered an FIR against the respondent and her family members due to extortion and other various acts. And as a counterblast, she initiated a 498 proceedings before the magistrate court. In that magistrate court, she clearly tells the marriage happened in Bangalore on November 16th, 2021. And she's not disclosed one single word about the marriage, which has happened in Dharmasthala temple on September 15th. So basically, the respondent is running a real marriage before the magistrate court, and she's appearing before the family court, and she's running on an illusionary marriage. That is the 498 proceedings. In that, the respondent clearly tells she's not even disclosed one single word about the marriage which happened in Dharmasthala. She clearly tells the marriage happened in Bangalore, Yelahanka, on 17th of November 2021.
What is your take?
She wants a decree of divorce for the marriage happened in Dharmasthala on September 15, 2021. If there is no marriage at all, how can she even claim a relief from it? In the FIR copy, what she is given to the magistrate court, she's clearly told my husband didn't have a job, he was residing in Australia, and he's false stated he's having a job, etc. He cheated me. And coming to the family court, she's telling he's earning around 8 lakhs per month, so I need 1 lakh monthly maintenance. The order she clearly tells on 14th of August, the case is advanced, advancement application is filed by the respondent, the case is advanced, no representation. So she's clearly misled the High Court, taking advantage of the number of cases the High Court is going to deal every day. She's misrepresented the facts and got unfavorable order of disposing the matrimonial case, which is running on an illusionary marriage in a year. Illusionary story. Even in a fabricated story under oath, there is no any essential ceremonies under Hindu marriage. So how can a decree be given for a marriage which never happened? My lord, this is regarding the application of perjury under section 340 read with 195 we filed against the respondent in the ongoing proceedings before the family court. The impugned order in page number 49 Annex E, the trial court stating that it requires evidence and it's a direction matter from the High Court, directed the office to register a miscellaneous petition and proceeded with the trial. So before this High Court.
Please come to the order where it is.
Page number 49 Annex E.
Yes, read it.
So the trial court states that the respondent filed application under section 340-195 of CRPC regarding fabricating the documents.
Please come to that particular 49. Petitioner present, both counsels present. Is it the order?
No, just underneath that, my lord. So it tells that it requires evidence and it's a direction matter. Therefore, office is hereby directed to register a separate miscellaneous petition. And the trial court just told us to go ahead with the trial without disposing the perjury application. So I'm before this honorable court requesting to direct the trial court to decide and dispose the perjury application first.
Why you should be?
I have my grounds. I want to make just 4 submissions regarding this. The first submission is the respondent in the ongoing matrimonial case seeks a divorce for a marriage which is solemnized on 15th of September 2021. That is her petition, which is in Annexure A. So what she's claiming in Annexure A is, in page number 27, her only prayer is to grant a decree of divorce dissolving the marriage between me and the respondent, which was solemnized in Sri Kshetra Dharmasthala temple on 15th of September 2021. So this claim itself is false because there was no any marriage solemnized on that temple on that particular date. The respondent.
How the court will know that?
I'll just make my submission, my lord. The respondent, prior to appearing before the family court, before filing the petition in front of the family court, she initiated the normal 498A proceedings before the magistrate court. That was also a counterblast for my FIR because I was the one who registered an FIR against the respondent and her family members due to extortion and other various acts. And as a counterblast, she initiated a 498A proceedings before the magistrate court. In that magistrate court, she clearly tells the marriage happened in Bangalore on November 16th, 2021. And she's not disclosed one single word about the marriage, which has happened in Dharmasthala temple on September 15th. So basically, the respondent is running a real marriage before the magistrate court, and she's appearing before the family court, and she's running on an illusionary marriage. So this is the fact. And to support that, my lord, I just want to submit a memo with list of documents. My lord, the document 1 is the wedding card, which is a fabricated and the false evidence which she is marked as evidence to prove the false claim of marriage which has happened in Dharmasthala. That is, it is marked as exhibit number P3. So the document number 2 is the endorsement from the Dharmasthala temple, which is run by Dharmadhikari Virendra Hegde, as well as from the jurisdiction police station of Dharmasthala, stating that there is no records of marriage between me and the petitioner at all.
Yes.
And the third The third document is the charge sheet, which is before the magistrate court. That is the 498 proceedings. In that, the respondent clearly tells she's not even disclosed one single word about the marriage which happened in Dharmasthala. She clearly tells the marriage happened in Bangalore, Yelahanka, on 17th of November 2021.
What is your case?
It's a matrimony, it's a divorce case. She's filed under cruelty.
Whether you agree that the marriage had taken place or not?
There was no marriage happened in Dharmasthala. There was a marriage happened in Bangalore.
Yeah, there was a marriage.
There was a
between
marriage.
you and the respondent.
Yes.
No, you're just basing on the fact that the dates or the places or where she has stated separately. I mean, the different places.
Yeah.
Now, according to you, it is perjury.
No. What has happened is, in the divorce petition and even in the affidavit in chief, what she is submitted before the family court, she is clearly told the marriage happened only in Dharmasthala and reception happened in Bangalore, which is also I've submitted in.
No. What is it? How is it going to change how is it like prejudicial to you, or how is it going to affect you?
The whole petition stands on the marriage. She wants a decree of divorce for the marriage happened in Dharmasthala on September 15, 2021. If there is no marriage at all, how can she even claim a relief from me?
Yes.
The marriage happened on November. I agree with that. She is my wife. And there's evidence, everything regarding that, regarding the essential ceremonies and various other things. She's not even given one single document about the marriage happened in Dharmasthala. And in a chief affidavit, what she's cleverly done is, she's cleverly annexed the photos of the marriage happened in Bangalore and claimed that the marriage happened in Dharmasthala. And she's clearly told 16th and 17th of November, there was no marriage happened, only reception happened in Bangalore. So that is clearly a false affidavit, what she submitted before the family court.
Yes.
And my second submission, my lord, regarding this, to prove a cruelty, she's produced some additional bills and other things, which has no legal value. It's clearly a fabricated one because the GST invoice doesn't have a GST claim, nor invoices claiming 15-20 lakhs has even an invoice number in it. And she's also given an audio transcript. In her affidavit, she tells that it is between me and my husband and the parents, but the transcript of the audio recording is not matching with what the affidavit is telling, nor it is authenticated by any forensic lab. So it's clearly not matching. The transcript as well as the affidavit, what she is given is not matching at all.
What is the hurry that this application should be disposed of first?
What is the two more submissions? So that is my second submission. The third submission, the court mentioned was, it requires evidence was the first one. The evidence is clearly placed on record by the respondent herself, where the marriage happened and etc. And she's also filed an application under Section 24 of Hindu Marriage Act, telling that she's unable to maintain herself and she's seeking a monthly maintenance of 1,50,000 as litigation expense. She's also filed an IA along with the petition. So what has happened now is, before filing the petition, in the FIR copy, what she is given to the magistrate court, she's clearly told my husband didn't have a job. He was residing in Australia and he's false stated he's having a job, etc. He cheated me. And coming to the family court, she's telling he's earning around 8 lakhs per month. So I need 1 lakh monthly maintenance. Nor any affidavits or anything regarding the income and assets and liabilities is submitted. So this is the fact. And once I come on record before the family court, the matter gets referred to mediation. Even before the mediation report comes back to the family court, she gives an SPA to her mother to prosecute the case. And the respondent, through an SPA with her mother, appears to the High Court for seeking a speedy disposal. So coming to the speedy disposal fact over here. So she's not only pled perjury with the magistrate court as well as with the family court. It's happened even before the Honorable High Court. So this is the original petition what she's filed to the High Court. It's a writ petition. It was disposed even before me contesting it because speedy disposal is going to be favoring both the parties. Even I agree with that. But once you're appearing before the High Court, you need to come with clean hands and exhaust all the remedies. And you need to represent the facts in a very clean way so that you don't have to play perjury in front of the High Court, my lord. So in this petition, what she's done, just to prove that she's exhausted all the memories, she's lied about me for the illusionary marriage. She's mentioned a number of things about me, but that is not my matter of concern. Well, I just want to submit this to you.
You can read what it is.
So in the brief facts in the writ petition, she clearly tells on 10th of August 2023, the petitioner witnessing the delay in the proceedings files an advancement petition before the family court and the family court rejected it. But there was no any advancement application filed on that particular date at all. It was filed on 14th of August, not on 10th. And the High Court, the Family Court didn't reject it. Didn't reject the advancement application filed by the respondent. The order sheet clearly tells on 14th of August, the case is advanced, advancement application is filed by the respondent, the case is advanced, no representation. So she's clearly misled the High Court, taking advantage of the number of cases the High Court is going to deal every day. She's misrepresented the facts and got unfavorable order of disposing the matrimonial case, which is running on an illusionary marriage in a year. So these are the facts.
Yes.
So coming to the legal principles of what the High Court and Honorable Apex Court is retaliated in the the perjury proceedings. Even the division bench of the Karnataka High Court, that is my ground number 34, is clearly told drastic measures have to be taken to eradicate the evil of perjury. And in a similar case, in the same Karnataka High Court, which was decided in the year 2021, it is a matrimonial case. It is filed by the husband against the wife, stating that she's lying on an affidavit telling that she's not having income, and she's filed application under Section 24. Similar case came before the Honorable High Court in 2021. So Honorable High Court clearly tells the perjury case has to be decided first, even before going ahead with the trial. The same principle is also followed by n number of high courts across the country. I've also attached the recent judgments in the memo. So what is going to happen now is, if the perjury is not decided, the first thing, the marriage has not happened in Dharmasthala. The cause of action itself is illusionary, because she's running on a real marriage before the magistrate court. What petition she's filed is on an illusionary marriage. And for a Hindu marriage, the essential ceremonies. And what happened was, when the trial court decided to go ahead with the trial, even before deciding this, during the admission, during cross-examination, the SPA holder of the respondent was cross-examined. My counsel clearly cross-examined, telling that, why are you stating false facts in front of the court when the marriage has not happened at all? She created another illusionary story. Even in her fabricated story under oath, there is no any essential ceremonies under Hindu marriage. So how can a decree be given for a marriage which never happened?
Yes.
Even if the marriage happened according to the respondent,
Yes.
for that illusionary, setup, what she's done, and for the false evidence, without any essential ceremonies, for the invalid marriage, can a decree be given, my lord?
Yes.
This is my submission. I just request this Honorable High Court to give a stipulated time frame of weeks or anything to dispose this perjury application first, even before proceeding ahead with the trial. So this is my only request. I come before this court.
Yes, please come. The present petition is filed, having got the party in person, peruse the material on record. The wife had filed a petition seeking divorce. It is undisputed that the marriage had taken place. According to him, the place where the wife had mentioned about the marriage is not where the marriage had taken place, and she had committed perjury. Now, in that regard, he has placed some documents before the court. All these documents are also relevant for the court to decide this divorce petition. Whether the marriage had taken place at Bangalore or at Dharmasthala, all those issues also goes to the root of the matter. In this case, this court finds that there is no urgency to decide it separately, and the court, in its usual course, can decide the application. And this court finds no reasons to interfere. Dismissed.